Tonight, we begin with a legal breakdown that federal court officials, constitutional scholars, and veteran trial attorneys had feared, anticipated, and finally witnessed. A courtroom collapse that unfolded not over weeks of testimony, but in a single explosive afternoon, an afternoon that shattered decades of courtroom precedent, an afternoon that left the defense scrambling for replacements, an afternoon that may have irrevocably altered the trajectory of Donald Trump's federal trial. What Trump's legal team did today crossed a line that the presiding judge had hoped would hold, and when that line broke, the court did not hesitate. They responded with precision, authority, and historic consequence. This was not a warning. This was not a reprimand. This was removal, full, immediate, and unprecedented in modern presidential legal history. For weeks now, there had been signals, not official court filings, not formal motions, just signals that Trump's defense team was preparing something dangerously unconventional. Trump's attorneys have been aggressive, yes, but they have been strategic in their aggression. Their moves have followed a certain predictability, a rhythm, almost a choreography that experienced court watchers had learned to anticipate. But what set off alarm bells in the federal courthouse this morning was that the rhythm went silent. Legal analysts who monitor high-profile federal proceedings know the indicators, the sudden change in filing patterns, the unusual sidebar requests, the visible tension between co-counsel at the defense table, the sudden absence of communication with court clerks. All of that went quiet. And whenever Trump's legal team goes quiet, it means something is about to get loud. Sources familiar with the proceedings described the atmosphere in the days leading up to today's explosion as pressure cooker with a locked lid. Defense attorneys had been increasingly confrontational with witnesses. They had tested the judge's patience with objections that bordered on frivolous. They had made statements to media outside the courtroom that directly contradicted positions taken inside. But none of that prepared anyone for what happened today. The defense wasn't just pushing boundaries anymore, they were demolishing them. And the federal judiciary, the institution designed to withstand exactly this kind of assault, was finally forced to respond with the most severe measure available. Early this morning, court officials detected what they described as a coordinated pattern of obstructive conduct, including behavior that had not been witnessed in federal criminal proceedings in over 40 years. These are the kinds of tactics that defense attorneys only deploy when they are signaling something very specific: delay at any cost, disruption of the proceedings, or outright contempt for judicial authority. Court snorts observers didn't know which category this fell into or whether it fell into all three at once. But what they did know was that Trump's legal team was changing strategy. And when a defense team in a high-stakes federal trial shifts strategy without explanation, even by the smallest degree, the court pays attention. The morning began with what appeared to be routine cross-examination of a key government witness. But within minutes, the tone shifted. Defense counsel began asking questions that had already been ruled inadmissible. They referenced evidence that had been specifically excluded by pittrial order. They made accusations against the prosecution that had no foundation in the record. The judge issued the first warning at 9:47 a. The second warning came at 10 days and 23 by 11s and 15 Warnings were no longer sufficient. What happened next would become the defining moment of this trial and perhaps of Trump's entire legal saga. The order issued by the federal court today was not normal. It was not routine. It was not symbolic. It was urgent. Court official after court official described Trump's legal team's conduct as unprecedented, deliberately obstructive, and perhaps most importantly, potentially criminal in its own right. But obstruction only works if the target hesitates. The court did not. In fact, their response today was among the most decisive and immediate we've seen in modern federal trial history. Here's what we know: within 90 minutes of the first major violation, the presiding judge halted all proceedings. These weren't the procedural pauses you see in ordinary trials. This was a complete shutdown, the kind of intervention that federal judges only deploy when they are preparing to take extraordinary action. The courtroom fell silent, the jury was escorted out, and then, in a moment that veteran court reporters are describing as historic, the judge addressed Trump's lead counsel directly. The words were measured, the tone was controlled, but the meaning was unmistakable. Counsel, the judge stated, You have repeatedly and deliberately violated direct orders of this court. You have demonstrated contempt for these proceedings, and you have left me with no alternative. What followed will be studied in law schools for decades. Tonight, court records confirm that the presiding judge issued removal orders targeting 3 members of Trump's defense team, including the lead attorney, who had recently been brought in specifically for what analysts believe was a strategy of maximum disruption. The court acted before the defense could file any motion to stay the removal. They removed the lead counsel. They removed the co-counsel who had been coordinating witness intimidation strategies. They removed the junior attorney who had been feeding inadmissible information to the media. In other words, the court snorts targeted the entire command structure of the defense, the leadership that would have made continued obstruction possible. This is what made the court's action so urgent. Trump's legal team's conduct wasn't just disrespectful, it was tactical. It represented the kind of coordinated assault on judicial proceedings that could have resulted in a mistrial if left unchecked. And the judge, understanding that fully, responded with force, not recklessly, not impulsively, but strategically. They didn't declare a mistrial, which is exactly what the defense wanted. They didn't allow a recess that could have enabled regrouping. They removed the problem at its source. They preserved the proceedings by eliminating the obstruction. Legal experts are calling this surgical judicial intervention, the precise application of court authority to protect the integrity of a trial without giving the disruptive party what they wanted. The remaining defense attorneys, those not removed, were given exactly 48 hours to present alternative counsel. The trial will proceed, and now it will proceed without the architects of chaos. And here's where the story becomes even more significant. Legal analysts now believe that Trump's legal team's conduct was designed to test the limits of judicial tolerance after months of pushing boundaries without consequence. They wanted to see whether the federal court would flinch under political pressure. But instead, the opposite happened. The court didn't flinch. They issued a response that was so swift, so decisive, that even Trump's remaining legal advisors noticed. You don't get a federal judge's full attention easily. But today, Trump's attorneys did. Constitutional scholars speaking with major news outlets under anonymity described the defense team's strategy as legal comicas, a way to create chaos in hopes of forcing a mistrial. But the court proved today that they remain both vigilant and resolute. Their actions were not only immediate, they were calibrated so precisely that the trial's timeline remains intact. That detail matters because it shows the court anticipated this possibility. It shows that the federal judiciary is not a passive observer of its own proceedings. They are active guardians of the process. Sources close to the prosecution described the mood in their camp as vindicated but cautious. They had filed multiple sealed complaints about defense conduct in the weeks leading up to today. They had warned the court that the defense was building towards something explosive. Today, those warnings were proven accurate. And the court's response demonstrated that even in the most politically charged trial in American history, the rule of law still has enforcers. As reports continued coming in throughout the afternoon, we learned more about the scale of the court's response. Well, court security carried out immediate escort procedures, forcing the removed attorneys to surrender their courtroom credentials before exiting. The clerk's office targeted all pending motions that had been filed by the removed counsel in the last 72 hours, flagging them for potential sanctions review. Federal marshals operating inside the courthouse reportedly secured all defense documents to prevent potential evidence tampering. This wasn't just a judicial reprimand. This wasn't just a procedural correction. This was institutional self-defense. This was the federal court system protecting its own integrity. And integrity is the one thing Trump's legal strategy has struggled to undermine since the trial began. For every procedural maneuver they have attempted, the court has countered with something that has neutralized its effect. Today was the culmination of that pattern. The defense pushed, the court pushed back harder, and now Trump finds himself in unprecedented territory. A defendant in a federal criminal trial whose legal team has just been partially dismantled by court order. Remember, Trump's team thought the court would never take such drastic action. They thought the political implications would paralyze judicial decision-making. They thought delay through disruption was a viable strategy. But tonight, The exact opposite is happening. The court has demonstrated it will act decisively regardless of the defendant's identity. The trial remains on schedule, and the defense is now operating from a position of severe disadvantage. Historians are already comparing today's events to watershed moments in American legal history. Moments when courts were forced to assert their authority against powerful defendants who believed themselves above the process. The comparison most frequently cited tonight is the Nixon era legal battles when federal courts similarly refused to bend to political pressure. But in some ways, today's events are even more remarkable because this time the court didn't just rule against the defendant, they removed the defendant's chosen advocates from the courtroom entirely. What makes this moment so consequential and so volatile is that Trump's legal team's breakdown happened at a time when Trump himself is under extraordinary pressure. His political advisors want to use the trial for campaign messaging. His donors want to see aggressive defense regardless of consequences. His media allies want daily footage of courtroom confrontation. His family wants the entire proceeding to end as quickly as possible. Trump is balancing these demands while facing the most serious criminal charges ever brought against a former president. And when leaders in that position make sudden moves, they're not doing it from strength. They're doing it from pressure. They're doing it from vulnerability. Tonight, that vulnerability is exposed for all to see. The strategy of chaos has failed. The attorneys tasked with executing it have been removed, and Trump now faces the remainder of this trial with a defense team that has been publicly humiliated and institutionally weakened. The political implications are only beginning to be calculated, but the legal implications are already clear. The court's written order, now publicly available, was designed to signal that the federal judiciary is not willing to allow its proceedings to be hijacked. The presiding judge said plainly that the defense counsel's conduct was inconsistent with the duties owed to this court and to the administration of justice. That is judicial language for you deliberately sabotage these proceedings, and you are no longer welcome here. You don't usually hear that tone from federal judges unless something serious is at stake. Legal ethics experts are now examining whether the removed attorneys could face additional consequences beyond their removal from this case, including potential bar complaints, contempt proceedings, or even criminal referrals for obstruction. The court made clear in its order that today's action should not be interpreted as the final word on the matter. That phrase is significant. It suggests the court is considering whether additional measures may be necessary. Meanwhile, Trump addressed supporters at an evening event in a defiant, combative speech tonight. He said, "They're trying to take away my lawyers because they're afraid of what my lawyers might prove." He said, this is a witch hunt like nobody has ever seen before, and now they're going after the lawyers too. And he said, "Woo, fight this. We will win this, and we will make them regret every single thing they've done." These are not rhetorical flourishes. These are statements from a defendant who understands just how high the stakes have become. But notably absent from Trump's remarks was any acknowledgement of what actually happened in that courtroom. No mention of the specific violations. No mention of the warnings ignored. No mention of the conduct that triggered the removal. Just defiance. And defiance without a functional legal strategy is not a defense. Here's what makes the situation even more concerning. Trump's legal team's collapse wasn't isolated. Along with the courtroom breakdown, Trump's social media accounts also launched coordinated attacks on the judge, potentially violating existing gag orders. Conservative media allies began circulating personal information about court officials in what critics are calling witness intimidation by proxy. Republican members of Congress increased their attacks on the Department of Justice, calling for defunding of the prosecution. All of this happened within the same 12-hour period. When Trump's orbit moves multiple pieces at once, it means something larger is underway. Legal observers fear that today's courtroom events may be just one front in a broader campaign to delegitimize the entire proceeding, regardless of what happens inside the courtroom itself. The court's decisive action today may have preserved the trial's integrity, but the battle for public perception is just beginning. Analysts are now considering several possibilities. One is that Trump is preparing to claim the entire trial is illegitimate based on today's attorney removals. Another is that Trump's team is attempting to manufacture grounds for appeal by provoking the court into actions that can be characterized as bias. A third possibility, the one worrying officials the most, is that Trump is attempting to create conditions for mass protests or civil unrest by portraying himself as the victim of judicial persecution. But today, the court took that card off the table. They didn't declare a mistrial which would have validated the disruption strategy. They didn't allow indefinite delays, which would have served the defense's political timeline. They didn't let the removed attorneys return after a cooling off period. They acted decisively. They demonstrated that chaos will not be rewarded. And they showed that the federal court system, whatever its critics may say, still functions. What we're watching now is a test of institutional strength. Trump wants to see if the judicial system will break under political pressure. The court wants to show that justice applies equally to all defendants. The Department of Justice wants to prevent the normalization of courtroom obstruction. And the American public wants to prevent the precedent that wealthy, powerful defendants can simply disrupt their way out of accountability. These competing interests will define the next phase of this trial. The court has drawn its line. Now, we will see who crosses it next. Tonight, we've heard from legal experts who are now closely monitoring developments. They say the removed attorneys have until midnight to file any appeal of the removal order. They say replacement counsel must be identified and approved within 48 hours or the court may appoint representation. And they say Trump's decision to attack the judge publicly is likely part of a broader messaging strategy intended to frame any eventual conviction as politically motivated. But the court is not backing down. In fact, the court is accelerating proceedings. Their response today, swift, proportionate, and irreversible, sent a message to Trump's team that obstruction will not be tolerated. And it sent a message to the American people that the rule of law remains operational. Tonight, for perhaps the first time in this trial, the initiative belongs entirely to the prosecution. The defense is in disarray, and the court has demonstrated it. Will not hesitate to act again if necessary. As the evening goes on, we expect more details to emerge about what exactly Trump's legal team hoped to achieve. But what we do know is that the court's action was timely. It prevented the trial from descending into chaos. It preserved the jury's ability to hear evidence fairly, and it established a precedent that will echo through federal courtrooms for generations. What happens next will depend on what Trump's team does in the next 48 hours. If they comply with court orders and present competent replacement counsel, this moment will be remembered as a painful but recoverable setback. If they continue the pattern of obstruction, the court has already shown they are prepared to escalate. They have shown they are ready to respond. They have shown that no defendant, regardless of past position or current political power, is above the court's authority. And tonight, for the first time in months, Trump appears to be genuinely uncertain. Mar-a-Lago is quiet, too quiet. And when Trump is quiet, it means he is calculating. It means he is choosing his next move carefully. Because tonight, Trump learned something. He has struggled to accept federal courts. Do not bend to pressure. Obstruction is not a legal strategy. And when you push the system too far, the system pushes back. This story is far from over. But tonight, one thing is clear. The trial will continue. The court will not be intimidated. And justice, whatever form it takes, is still on the table. And we will be here watching every detail as the next phase unfolds.